Good afternoon, everyone, and welcome. Today's webinar is on privacy legislation, how to craft effective privacy laws. And I've got with me some terrific guests today who've written, all of whom have written extensively on this very issue. So first, I'd like to introduce Lauren Scholz, who's at Florida State. She's written a number of articles about the fiduciary theory of privacy, and her most recent piece is on the importance of a private right of action in privacy laws. So I'm really excited to talk about that because, let's say, that's a mildly controversial issue. Um, we have Margot Kaminski at Colorado. She's written a number of pieces on the GDPR, on privacy law generally. And her most recent piece is about how we should be maybe a little less harsh on criticizing some of the new privacy laws out there. And I'll let her talk about some of her thoughts on that. And then finally, we have Ari Waldman of Northeastern. His new book, Privacy Unbound, is a very strong critique of a lot of recent privacy laws and the approach to privacy that a lot of companies are following. So I think we have a really interesting range of perspectives on this issue. And briefly, what prompted the idea to have a webinar on this issue is that we're really in a kind of golden age of privacy law. All around the world, we're seeing countries pass privacy laws. The EU with the GDPR starting in 2016 when it was enacted to when it became effective in 2018. A lot of countries around the world are starting to add provisions to make their laws more GDPR-like or pass laws that are in the GDPR footprint or modeled after the GDPR. And then in the United States, we've seen this movement to passing new privacy laws, California being the first to pass I wouldn't call it comprehensive, but it's one of the larger scoped privacy laws out there. And then other states have followed suit. Virginia, Colorado, and now we see Utah has joined the mix. And there are bills pending in quite a number of states. So this is the age when finally we're seeing all this legislation on privacy. But and it's sort of a good time to have a conversation. Well, is this law any good? How can this law be improved? This is a great opportunity as these laws are being forged to figure out, how do we create a really good law? I've been critical of a lot of the laws. I've been critical of California. I think it can do a lot more. I don't necessarily think it shouldn't have been passed. I think it should have. I think it's a good try, but I think it ultimately has some problems, which we'll get into. So basically, I'd like to begin with. Well, I think actually maybe a good spot to begin is with Ari, because you have one of the most blistering critiques of privacy law out there. And I guess, could you sum up in a quick nutshell kind of what your take is on, the approaches that some of these state laws are taking and how your views of privacy law fit into that, or how you would assess those laws?
Sure. Well, first, thanks for inviting me to join this webinar, Dan. And it's a pleasure to be here with my friends and colleagues, Lauren Scholz and Margot Kaminski, who are great scholars, even when we disagree. And I shouldn't say even, it's like, both Lauren and Margot are making extraordinarily powerful arguments about the benefits or what should be in these privacy laws. And that's incumbent upon those of us who may be even more critical to respond to these, to their cogent and powerful arguments. So, and I hope we can engage in that way in this conversation. My concern about these privacy laws are numerous. They're discussed in this book, as I noted right behind me. But in a nutshell, I'm concerned about three things. I'm concerned that the laws rely too much on the good graces or goodwill of the internal processes of regulated entities themselves, such that the effectiveness of these laws are entirely dependent on how earnest or honest or how effective the effective an internal structure like a privacy office or a privacy officer or an impact assessment is in putting the brakes or engaging in friction or adding friction to the process of data extraction. And as I've shown in my research and in my book, that just is not the case. They do not act as stopgaps, or they do not act to add friction to what's going on inside the company. Instead, they are morphed. They are recast in order to enhance what the company is doing. The second concern that I have is all of these laws focus on individual rights. You can look from the GDPR to the weakest law that we have here in the United States, maybe Utah's law that was recently passed. All of them include individual rights to access and other forms of individual rights. And it's not that individual rights are necessarily bad. It's that they're going to be completely ineffective in solving what are really social problems, as some of my colleagues have argued. As in addition, it also sets bad norms, right? One of the key problems with what I'll call the first wave of privacy law, notice and choice or notice and consent, is that it put all the onus of enforcement on us. We had to check and adapt our privacy preferences from website to website and from app to app. Focusing on the individual rights of access and transparency and correction, again, puts all the onus on us. And not only are humans just generally incapable of doing that, but more broadly, I'm concerned that this is setting the norm, right? It sets the idea that privacy is something that is our individual responsibility. But like climate change, where industry has engaged so deeply and spent so many millions of dollars telling us that it's our responsibility to solve individually the problems with our globe by reducing our carbon footprint or recycling that piece of plastic, while the law does absolutely nothing about the emissions from the airline industry, right? The enforcement or the setting norms that this is an individual's responsibility is just the absolute wrong way to go. And my third concern about these laws is that they exist within a system that rather than regulating, they are legitimizing. So when even the most robust kinds of laws, let's assume for the moment that the GDPR is among the more robust. I'm not arguing that it is, but let's assume that it is. What these laws do is they set rules for what to do with data once you've collected them. And instead of, and by setting these kind of rules of the game for data use, rather than upset the harmful and manipulative business model that is really should be the core that we're attacking here, what they do is they legitimize the process. So when you pass a law and all it does is it sets some minimal guardrails around the behavior that companies are engaging in already, that's not regulation. That's legitimization. That makes it even easier for these companies to behave in that way. So there are tons of other concerns, but I think those are the three largest clusters of my concerns with the second wave of privacy law.
Dan, you're on mute.
Okay, sorry about that. I also hear some background noise somewhere. So I'm curious what folks think about what Ari said and Ari's speak, and ultimately, I think his takeaway is kind of these laws do more harm than good, and we're probably better off without them. I mean, do you agree?
No, as Ari well knows. So first, some context. I want to explain a little bit where I'm coming from. I consider myself to be a pragmatist in some senses of the word. Before I went into the academy, I very much considered going to work at one of a number of civil liberties organizations. And so a lot of my mindset is trying to figure out, what can we actually do? What voices do we need in the room to get to what we can actually accomplish? And what is sort of what's going to be the best compromise, and where am I going to be with respect to that in order to make that happen? The other context that I want to add to this is that I'm very much a comparativist. So as Dan said, I'm coming to this. I don't know what that sound is, but I also hear it. I'm very much coming to this from a comparative background, looking at what's been going on around the world, looking at what's going on in Europe. And so when I look at the laws in the United States, I'm by no means an apologist. I certainly think that there's a lot that's not there. And Ari's concern about privacy washing or legitimization is a very real one. At the same time, here's the pragmatist part of my speaking. So if our topic today is what makes a good privacy law, I'm just going to put something out there. What makes a good privacy law is a certain regulatory structure. And one way to write a good privacy law is to get legislative compromise around something you can pass that's kind of vague, and then get Paul Ohm to come in to do your rulemaking. So if people haven't been paying attention, that's what's happening in Colorado right now. I have no insight into what Paul, who is, as most of you know, a professor at Georgetown, has been writing in privacy for years and shares many of Ari's views and many of all of our views. I have no idea what will end up happening in the Colorado rulemaking process. And so I guess I come into this with a little bit more pragmatism and optimism, thinking like, let's kind of wait and see what happens. Let's see what happens in the California rulemaking process. Let's see what happens in the Colorado rulemaking process. Because some of these laws that we are dismissing out of hand because of what we see on paper actually have the potential, in my view, to establish some real teeth in practice. Okay, the other thing I wanted to say just briefly, this is echoing the piece that I recently released on the case for data privacy rights, is that I by no means think that individual rights by themselves are enough. I fully hear and agree with the criticisms about the co-opting of individual rights as a way of offloading responsibility. I fully agree with and believe in the sort of behavioral economics and psychological literature that tells us how easily individuals are overwhelmed or manipulated. All of those things I totally agree with. I also think that dismissing individual rights and saying what we need to do is enact a regulatory set of mandates that say you can't do this and you can do this is both not realistic about what we can get enacted in the United States. And maybe that's, again, to the voices in the room, like, it's great to have people say this is not realistic and this is what we should be doing. Like, I applaud Ari for doing that. But I think that if we tried to enact a privacy law that didn't have an individual in it in the United States, we'd be missing on the thing that motivates the enactment of a lot of these laws. I think that with respect to my First Amendment background, I worry that a law that was all restrictions and didn't have an individual at its center would potentially fail in First Amendment challenges, which are certainly coming. And then I clued in on this as part of the sort of concern about regulatory design. The part of me that's really interested in, like, how do these things actually operationalize, which I think is very, I hope Lauren can add to that, is, thinks about the ways in which, and I'm thinking of Jeff Auslus's work in Europe, thinks about the ways in which individual rights can actually be a crucial component of a broader regulatory regime. So let's say we have these laws where there's a lot of delegation to the private sector. And in that delegation of the private sector, there's a lot of capture, which is essentially what Ari is describing in his book. One way to get at that capture, and this is in all forms of regulation, is to try to use some form of transparency. We don't have a private sector FOIA in this country. We don't have a private sector privacy act. And what we potentially do start having with these laws that focus so heavily on rights of notice and rights of access is, you can see it in one of two ways. As Andrew Selfs has characterized it, you can see it as a policy feedback loop, right? Where we're starting to get more transparency into what these companies are doing through individual access requests or individual notification. And so we get more indignant and maybe we enact stronger laws. Or we see it itself as a market enforcement mechanism where companies potentially get shamed for what they're doing. And you potentially, I know there are all the network effects issues, but you potentially have customers threaten to leave. So I am less pessimistic. I am more pragmatic. And the last very quick thing I would say is that I think some of the divides that are happening in our community come from a characterization of what, in my view, are actually data protection laws as privacy laws. Like, I don't think these laws are privacy laws. I think we call them data privacy because that's the word we have for it in the United States. These are data protection laws. What does that mean? That means that there is a gap in the US regime for laws that actually regulate privacy. We have a weakened set of privacy torts that are the individual rights of action to sue when we think that behavior is wrong. And that is not what these laws are being modeled after, nor should they preempt the existence of what I think are really true privacy laws. All right, with that, I'll turn it over to Lauren. I'm really excited to hear you talk about private right of action.
Okay, so I think that the sounds could have been coming from me. My neighbor is currently cutting down a tree, and I moved to the room in my house that's furthest away from it, but I don't know. I can still hear it. Hopefully you guys can't. I put on headphones, which are bright red. So in any case, so much to say about what's already been said, and sort of I have a couple of interventions. How do we, first of all, there's what types of law should there be? What types of things should be wrongful in terms of data protection? I agree with Margot that the state laws are predominantly data protection laws, which may sort of indirectly protect some privacy interests, but they fundamentally are data protection, but notwithstanding that. So basically, what rules should there be? And the question is, the second question is, how are they enforced? Who enforces them? I think Ari brings up a series of related issues when it comes to the laws that we have been choosing on the state level. A central issue is the reliance on goodwill of regulated entities. And we have a kind of model in that, well, not a model of that, or a long-standing example of this, which is the current preeminent regulator of privacy law, which is the FTC. Ultimately, while they don't issue rules, they have a general standard of avoid deceptive and unfair behavior. And if you don't do that, then we'll begin an action, and then there could be a consent order arising from that. And if you violate that, you could face some consequences. So there is sort of a carrot and stick element going on there. And I can't help but think it shows both the advantages of having regulatory entities involved in regulating corporate practice, but I think it also shows its limitations. And I think that nothing really shows that more than the sort of 2019 consent order, which was associated with, the biggest fine in history for Facebook. They effectively openly flouted the terms of the previous consent order. But I think it does show the systemic problem, which is even sort of shaming and a consent order which mandates particular internal practices and monitoring, doesn't actually stop the bad practices because it's not enough of a disincentive. So if the companies are virtuous and they want to adhere to practices, they will. But ultimately, if the economic benefit outweighs the negative one, then they're going to keep going. And I do think that there's a tendency. Well, that particular consent order was controversial. It was 3-2. Two commissioners were like, "This is too open of a flouting. $5 billion is not enough. We actually do need to pursue litigation." But ultimately, litigation isn't normally the FTC's bag. All this to say, I think we need, in order to have more transparency, more of a conversation, more accountability, a combination of public and private regulators, because there is a tendency for, administrative agencies to kind of attempt to compromise, to kind of attempt to split the baby, to avoid actual confrontation. And the advantage of private litigation is every single interaction that a company has with an individual is a potential opportunity for a failure to meet a standard of a law to be a subject matter that they can be held accountable for. This adds a whole lot of uncertainty, which is why companies don't like it very much, right? They like the reasonability and judiciousness of the state or federal regulator, as opposed to the potentially unhinged plaintiff and the economically motivated plaintiff's attorney. But the problem is, if we have agency capture, agency underfunding, we are just going to get less accountability. And my concern here is when we look at the privacy statutes that have been most effective in actually changing corporate behavior in the past, they featured a combination of public and private enforcement. So while there are some sort of broad questions that we can ask, which is what type of rules should we want? What types of things should be, what type of burden should be imposing on companies or other actors that might be holding data? I think it's as important a question to consider who the enforcer is, because in many, many areas of law in the United States, from everything from securities to employment to civil rights, these are complicated issues that pervade society. You actually have both public and private enforcement, because we do need to have a large group of enforcers to have to provoke these conversations, even if, let's say, state actors don't particularly care to do so. So I think that my main intervention here is, I actually think, to sort of respond more particularly to what Ari and Margot were saying here, is while private rights of action don't fully address these overall issues of, let's say, so many of these data protection laws, some more openly than others, let's say Utah probably most openly, are just sort of ways of legitimating self-regulation, more or less. I think private rights of action are sort of a check on that, insofar as who enforces and how it's enforced is kind of outside the closed circle of sort of industry actors and people who are regulating those actors, which, as we all know, there's a revolving door. And he also mentioned that the laws that we do have, which I agree with Margot, not only is there an inherent element of individual rights in privacy law that tends to be present in American jurisprudence, I think there should be, right? I think privacy is both a social right, a social interest, and it's also a personal interest. I mean, I think that's sort of the thing. A harm to me can also, I can be harmed directly, but I also can be harmed as a member of a group. So I do think that it's an important element. But as Ari was saying, there is a sense in which these laws focus on individual rights, which puts all the onus of enforcement on individual people. I think a big problem with the status quo is there's a focus on individual rights without giving individuals a tool to enforce those individual rights. So if there's a mismatch between the form these rights take and the avenue of enforcement, and I think those two should match each other, because no one's going to care more about your individual rights than those individual people. So I think that it's not only a way to hold industry accountable, it's a way to also hold regulators responsible. So Schrems 2 actually began because he sued because the Irish regulator was not taking the problem as seriously as he thought they should have been. It's an action that we don't have here. You can sue the regulator. So even when you have, all the public regulation in the world and sort of a public regulator that takes these issues seriously, sometimes there can be points of view and perspectives from private plaintiffs in the private sector that can more effectively fight for those rights. So whether you disagree with the individual right framing or not, it certainly is part of how we look at things in the United States. And I think that as long as it is going to be part of how we look in the United States, there should be a match between the form that the right is described in and also the manner of enforcement. So those are just sort of my preliminary remarks. Also hearing sounds, but
I think there's one thing that's already clear from these excellent comments from Lauren and Margot, is that I think we all agree, even if our specifics or our perspectives are different, I think we can all agree that passing even the best one privacy law is not going to solve the problems, because all of these pieces are part of a larger structure of governance. So for example, one of the things that Margot mentioned is that if we want, one of the ways transparency rights can work is if they create this feedback loop, right? They require, they would create this feedback loop so we learn more and more and more. And also that there's the shaming possibility, right? That allows people that if things aren't going too well, right? If we learn that these companies are acting poorly, they can go somewhere else. But note how that's great, but that also needs somewhere else for people to go, right? And it also needs people to finally exercise their individual rights, as Lauren was just saying, right? So private rights of action also, right? Private rights of action, if it's just like turning on an off switch tomorrow, that's not solving a problem, because our federal courts are screwed up and our state courts are screwed up, and the people that win most cases in the federal and state courts are businesses, right? So we need structural change in that area, in this other area that we don't normally consider the realm of privacy or data protection, for these things to work. And that's also true for what I would call like the third wave of privacy, even if we don't all agree on what those might be. But any substantive restriction on what companies can do, whether it's banning micro-targeting or simply regulating the business model or licensing models or whatever, right? None of those things can work individually. So I think the community recognizes that, and one of the things that I think industry really needs to learn is that we're setting strong norms here. Anyone who takes actions, and industry takes actions, when legislators take actions, especially in a new wave, we're setting norms about what's going to come later as we become path dependent. But also what we want to become path dependent, what becomes the norm, has to be part of a larger structure of reform. And that's one of the reasons why we might disagree. I might be much more pessimistic about our ability to engage in those other structural reforms for those otherwise great things that Margot was talking about to have any effectiveness whatsoever.
I don't want to jump in front of Dan. I just wanted to say, Ari, I'm equally pessimistic. I just cloak it in pragmatism. I also just wanted to just briefly say two things. So one, Lauren, I'm so with you. Like I wish we could get a law passed with a private right of action, and just say that. I'm trying to figure out what else can we do, given that that's hard to do. And one thing that does concern me about the private right of action is TransUnion, right? It's standing. And the fact that there seems to be sort of a Swiss cheese approach to standing in privacy laws that's based on analogies to, outdated torts. So I'm curious about your thoughts on that. Second thing I wanted to say is that there's a great question or comment from Lydia Payne Johnson in the comments, and I wanted to speak to it for a second. So I want to be really clear. I think the only way in which enacting all these laws with these FIPS, with the individual rights at their core, is going to get us anything different from what we've had over the past 20 plus years in the United States is if we can start putting in really meaningful versions of notice and consent. And I am not a notice and consent apologist, for those of you who know me. But the example I give at the end of the essay on individual rights is the example of what happened with Apple, right? If companies want to actually get our consent or get us understand that we're saying no, they can do that. We've had two different reports now, or multiple different reports, about the rate of Apple users that have decided not to be tracked through iOS. And one of them is as high as 96%. right? 96% of people said no. And the result of that was a big structural change. It wasn't a lawsuit, but it was that Meta's stock dropped by 25%, right? 25%. So, I think about, again, these regulatory structures where we have these vaguer laws and opportunities for rulemaking. And I hope, I don't know, but I hope that these various AG offices or privacy agencies are going to draw on what we know about how people can actually operationalize, a right to refuse or a right to opt out in a way that lets them do that, that starts to get at some of the larger structural economics that Ari is concerned about.
So I'd love to jump in. There's so much to talk about. On rights, I recently wrote a piece called "The Limitations of Privacy Rights," and ultimately, I don't argue that we should get rid of rights, that laws shouldn't have them. I think they're important, but I think they are made to play too much of a role in the law, and too much weight is put on them. They should really be a supporting actor, not a lead actor. And the reason why is that they don't scale. You can't exercise all these rights for all these companies. So what am I supposed to be, like a permanent proofreader and write to all these companies and proofread my records and correct them? And I'm supposed to write to the companies and figure out like when the information is no longer relevant for whatever purpose they might have had for it and ask for it to be deleted. And then I'm supposed to do this and that. I don't have time to do that for all these companies. It's not my job. And I don't know how am I supposed to figure out when it's relevant or not? And then they get data every day. So, a big company, a big data company, they're going to get data about me constantly. So I have to do this not just once for that company, but routinely. And so much burden is put on me, a consumer, and and a lot of consumers don't know enough to really make these judgments. And then on top of that, the information disclosure, it sounds great. Oh, wow, you can get all this information that you gave to a company. But then you get this and it's like a data dump. What does it mean? Okay, they got a lot of information about me, but really what matters is how it's going to be used and what's going to be done with it. And that's really complicated. And so we get you get like data dumps and all these rights. And then when people don't exercise them, which most people don't do, because most people don't even read the privacy notices, then, oh, it's your fault. You don't care about privacy because you didn't do all this junky, chores that we wanted to make you do. And now people don't care, but we can just keep doing what we're doing. That's a problem. And I think we need to approach it a little differently, not to get rid of rights, but we need something more. We need something that really holds companies accountable. We need true, if we're going to have I think there should be a big sandbox where, companies should be able to use data. And I don't think we should just shut off data and stop companies from doing anything with it. So there should be a sandbox, but there needs to be boundaries to the sandbox. There needs to be lines that you can't cross or very hard lines to cross. And we need to have real accountability. I completely agree with Lauren. A private right of action is important. It's an important component. I don't think that alone can do it. We've seen the privacy torts have not evolved. They stopped evolving in 1960 when Prosser actually talked about just how amazing the development was with privacy torts developing from an 1890 article by Warren and Brandeis. And he said, look, there are 4 torts that the courts created in response to it. And once he put them forward, the courts stopped innovating and stopped coming up with new torts. And so they really don't fit a lot of the modern problems. Beyond that, a private right of action in laws, it used to not be that controversial. There used to be private rights of action in privacy laws. It's only, and that was at a time too when, industry used to oppose a comprehensive federal law. So now the strategy is, yes, we want a comprehensive federal law because that's going to preempt the state laws and preempt everything else. And they also now suddenly the private right of action is this evil thing that's terrible, unprecedented, but it's not. It's been a standard piece of privacy laws, and it wasn't that controversial until more recently, where suddenly it's become the lightning rod, and often, oh my gosh, the law is a private right of action. There's no way it's going to pass. And all the new state privacy laws don't have a private right of action, or very limited private right of action, which is going to be limiting. But I agree with Lauren that that agencies just don't have enough resources to go after all of the cases. So you look at who did the FTC go after? The violations are ridiculously egregious. They're outrageous. Like, what you have to do to get the FTC to come after you, it's really bad. So you don't have cases pushing the envelope in the gray, and that's really what kind of makes the law develop and grow, is kind of pushing the gray areas, being the norm entrepreneur. But if you don't have the resources and you can only go after, the worst of the worst, you're just doing too many slam dunk clear cut cases and not enough. So the private right of action, basically deputizes a bunch of private attorney generals to go after companies. And I agree, our litigation process is deeply flawed. It's ridiculously expensive. That most of the cases settle. There's a lot of problems with it, but until we actually have regulators that are not subject to capture and that are actually adequately funded, a private right of action is a great enforcement tool that the laws use. So I think there's a lot of value to it. But as far as what the laws should do, what they're not doing, I think the California approach is warmed over notice and choice. And what makes me a little sad about California in particular is that Alistair McTaggart, the creator of the law, he had a blank check. I think that referendum would have passed if it said, like, ban all tech companies. People would have passed it. I think pretty much anything would have passed. He could have done anything.
Two blank checks.
Yeah,
Yeah,
twice.
They could have done more, but like, they didn't do it. I feel like why not push a little more? I don't think you have to be radical. I mean, I agree with Margot that Ari, I think, wants a kind of radical restructuring of the basic foundations of
everything.
Needed, but I think probably we're not there.
But I think there's a reason, Dan, if I may. I think there is an identifiable reason why, to take your point, Alistair McTaggart didn't go forward, and it's part of my concern about, let's call it, the more moderate approach. But let me say first, I very much value that moderate approach, but I think the moderate approach also has to value those speaking outside the current Overton window, because what's currently not within the Overton window today can certainly become part of a discussion tomorrow, right? So someone has to be making that conversation. But the reason why I
totally value that. I want to be very clear about that.
Of course you do, and I wasn't suggesting otherwise. I think the reason why they didn't go forward is because we are in this frame. It's related to what I was saying. Like, we're in this frame of what is data protection law, or what is privacy law. Well, the stuff that passes for data privacy law, or whatever phrase you want to give it. The phrase data protection versus privacy doesn't interest me as much at the moment. But what passes for law in this space right now happens to be individual rights, compliance, and privacy impact assessments, and record keeping, and transparency. That's what passes for law, such that you look at civil society proposals, there's that foundation, and then there's icing, some decoration on the cake, right? And no matter where you go in the left-right spectrum, from the Future of Privacy Forum pro-industry to Privacy International, which is has a wider mission, the foundation is all the same, because we are on this path, right? And that's one of the key reasons why I think, even though privacy law in this second wave is different, right, we're still on this wrong path. Which brings me just very briefly to a comment posted by Julia Muccini, I hope I pronounced that right, about how we feel about companies such as Amazon and Microsoft helping to author privacy laws, which goes back to Dan's point about how these companies want regulation, right? They want regulation, but they want the right regulation. And one of the more radical things that I have said at some of these presentations is, I think the first step to take when we're writing privacy laws is to get Amazon and Microsoft, et cetera, out of the room. There is no place for regulated entities to be in the room while legislators are writing the laws. I don't care if someone says, well, we're going to be the ones implementing it. Yes, you're going to be the ones implementing it, so you're going to do what we tell you, right? Instead of Amazon and Microsoft and Google helping to write these laws, let's go with an even more robust version of what Senator Sherrod Brown did. Senator Brown is the Democratic senator from Ohio who wrote a proposal, the Data Act or DATA, in which he did not consult industry and built a law. Yes, that's not perfect. It has some individual rights. It has some compliance that I've critiqued, but it also has a civil rights approach. It also reflects the need for marginalized populations to have their information protected. And what I talk about in a forthcoming piece about privacy as performance is that what we need one state. We need one person to just do something different, right? To provide an opening, to provide a path for more progressive legislatures to realize, hey, I am not limited to these 6 FIPS, these 6 rights. I am not limited to relying on privacy impact assessments that chief privacy officers just reduce to checkboxes, right? I'm not limited to that because look, there's this other guy, this other person at another state who said, well, actually, we're going to impose criminal penalties. Actually, we're going to require the companies give over or delete or stop using the algorithms that were created from ill-gotten data, or that we're going to limit the kinds of information or the kinds of uses for data. Look, there's someone else. Here's another option. And once we have another option, we're going to see that suddenly this hope that we have that people are going to start exercising their transparency rights are going to seem less important because we're going to see another wave. We're going to see other options taking place. And sooner or later, those are going to become mainstream. And if we just resign ourselves to a world in which we have to get something passed now, my concern is that we're going to be path dependent well into the next several decades when companies are starting to design even more data extracted technologies.
So I just want to come in on a couple of points because this idea of path dependency is something that I also worry about. Something that I'm really worried about, and one of the reasons why I do write about private litigation, private rights of action, common law approaches, is I feel like I'm talking to a child, but where do laws come from? I mean, we all know the story of a bill, but laws often come from crises, either something bad happening in the world, but even more often, they come from a case that was decided badly that makes a legislature upset, or a case that was decided so well that a legislator looks at it and is like, you know what, I don't want this just to be an idiosyncratic interpretation by one judge. I think that we can expand on this. And because the predominant attitude of the judiciary and legislators for over the past 30 years has been, let's economize on litigation. Let's economize on litigation. Litigation is bad because it's expensive. But one of the things about things that cost money is you get something for it. And litigation brings returns not just to the participants, but they're also paying for a public service of bringing out of the private sphere controversies about what is considered right, what is considered wrong, what's considered over the line, and judges have to decide these hard questions in public, and sometimes they get it right and sometimes they get it wrong. And what things like standing have been used for is to avoid getting to the merits of understanding boundary setting in the information era. So now 30 years in, people are talking about the brave new information age. It's been a while, and unfortunately, because so much information is controlled that we get from these companies, we don't have, there's a great article called Discovery as Regulation. Discovery is so expensive, worst part of litigation. Well, it also allows us to learn things about corporate practice, right? It also allows us to see experts. Experts are expensive. Oh, they put numbers on things. And the plaintiff's experts come in and the defendant's experts come in and they put different numbers on them. And that allows us to have a public conversation about these sorts of things. And the reason why it's so hard to come up with privacy legislation, and so we keep going back to the FIPS and we keep going back to cases from 1995, is because there are few, we have our private rights of action cases that existed from before, FOCRA, TCPA, et cetera. And we still have cases under those, although we do have, there is increasing uncertainty about standing on those cases. It's not preempted, but it's something you always have to worry about. And I think we need to reconsider these things because the lack of information from the private sector is actually part of what's making our discussion, the discourse, so cramped. So I wanted to respond to something that Margot brought up earlier, which is, I think, really important, which is one of the reasons why private rights of action are not sort of a panacea by themselves. I think Ari made a very important point, every time, every individual article or every individual intervention we make, it's well, this will make a positive difference, but the positive difference is capped by its interaction with many other issues. So, well, I think even with the existing limitations, a private right of action is useful in privacy legislation. There are still problems. So, for example, TransUnion, Spokane, it all comes down to an issue in federal courts, which is, so regardless of whether federal legislation has actually said that this is a wrong, the Supreme Court has decided that they need to find that the harm is concrete. They repeatedly use the term concrete, which is a metaphor. And ironically, they're not that concrete about what they mean by concrete, which is why it's so inconsistently applied. But one thing I can glean from it, which is definitely the case, well, there are two different ways of responding to this, and how can we shore this up, make it more likely and more clear that private rights of action and privacy cases in general, whether it's the torts or new ones, can succeed. So first of all, I have a paper called Privacy Remedies, which addresses this pretty directly. Unfortunately, Remedies is not part of the standard 1L curriculum anymore. It used to be something that lawyers took in the second year, but there's a widespread lack of understanding of this issue. Actually, one of the amici briefs in Spokane was a group of Remedies scholars being sorry, excuse me, but you do know that the only form of relief, compensation, is not the only form of relief or measure of relief available by a court. There's also restitution. There's also unjust enrichment. So there's a very long common law tradition, predates the United States, of actually according relief and even having causes of action that are based in the idea that someone else unjustly benefited from you. And that's what it's based on, not based on loss. So the harm or the concreteness of your harm doesn't have to be relevant to your remedy. So sort of one of the solutions is, and this is not always the case with every privacy plaintiff, there are certain types of privacy invasions, such as non-consensual pornography, which is, really what we're talking about is harm to the plaintiff here. But in a lot of these more commercial consumer privacy, where you're basically being taken and modified and exploited, a lot of what is happening here is parties are appropriating valuable information about you and making billions of dollars. But indeed, there's precedent for this as well. The way that FTC handles privacy and security cases, with the exception of the Facebook settlement that I discussed, is typically they measure, when they're looking at their fines, based on benefit to the not defendant, the party that breached the consent order. So in the Google Buzz consent order, for example, Google was charged what they estimated is 5 times as much as how much they benefited, right? So the idea here is what we're looking at that. Well, the reason why it's wrong is not necessarily the harm in the first place, but it's wrong that someone acted in such a way such that they wrongly took something and gained wrongfully from it. So I think one big way of addressing this is saying, look, we're not even looking for harm. We're actually, that's not why these plaintiffs are in court. If you want to say whether or not the relief is speculative, if you're saying that the relief is going to be in the form of restitution, it's hard to say that that's speculative, because these business models are making money. So in order to say that that measure of relief is speculative, you would have to sort of allege that this was a loss-making project. But secondly, I want to point out the role of state laws on data privacy. And I mean, even a state law like Utah. So one of the things that the Supreme Court says they take into account when they're thinking about whether or not a harm is concrete is not only sort of traditional, old school, common law ideas, although they don't know what restitution is, awkward, but whatever. But they also say that they're taking into account They don't say that what the judgment of Congress is irrelevant. In fact, they say legislatures are very good, particularly good, maybe even better than us, at figuring out what harm is. And I think the mere fact that many state legislators are increasingly recognizing privacy as a subject matter for protection recently is going to make it harder and harder for courts to allege with a straight face. I mean, courts are bold. Who knows? Who can say? But I think the increasing amount of privacy legislations, whatever might be in them, is an argument that this is some form of harm, because that's part of the test for what a concrete harm is. Like, if legislatures are recognizing it, it's not automatic, but it's a sign. If many state legislatures recognize it, that's also a sign.
Yeah, Lauren, I totally agree. And there have been some good conversations about like how state legislatures can basically include in their preambles or their legislative history ways of characterizing these harms, based a lot on Dan's work, I might add, and Danielle Citron's, and do this in a way that does build that norm, right? So I'm within the Overton window, but we're pushing the Overton window. Ari's standing outside the Overton window and trying to break it. So the thing I wanted to say in our brief remaining time, or things I wanted to say. One, I wanted to say that Lauren's comment about courts not knowing what restitution is awkward is my favorite quote from the entire conversation. Two, I totally agree with Dan that individual rights are not enough, and I've written a lot about this. And the weakness of this is from a piece that I co-authored with Anupam Chander and Bill McGivern. The weakness of the CCPA is that it is all the first half of the GDPR and none of the second, right? It is all the FIPS and none of the compliance. I know that's a dirty word, Ari. So my disappointment with the U.S. laws, if I can give criticism for a moment. My disappointment about the U.S. laws is that we don't have a history of data protection authorities. We have the FTC, right? We don't have individual state capacity at AG's offices to be DPAs. And so the real puzzle for us in my book is trying to figure out how do you get at the, I would just say regulatory enforcement as opposed to compliance. How do you get at the substantive rules for companies plus enforcement of those rules, given that we don't have that institutional history? I think Lauren's suggestion of private rights of action is definitely part of it, but not all of it. And again, I remain openly curious about what's going to happen in both Colorado and in California, and particularly where there is this new privacy board. Last thing I wanted to say is, to the Overton window, I wanted to throw in some optimism about places where I do see it getting shifted or even potentially broken. So the other place of focus for me in the last couple of years has really been on, whether you want to call it a subset of data protection or data privacy, or you want to call it a closely orthogonal subject matter to these things, has been on algorithmic accountability or regulation of artificial intelligence. And there, the dominant approach has been these impact assessments. I have been plenty critical of these impact assessments, even as I've been trying to get what I can out of them in terms of transparency and accountability. But I think the way they're being deployed in the US is largely pretty superficial and, ethics washing or privacy washing. But there are a couple of examples that make me kind of hopeful. So one, there was a recently dropped bill on a federal level that came from Wyden and Booker and Clark. It's the revised version of their AI Accountability Act, or Algorithmic Accountability Act. And in that bill, first of all, they require consultation with impacted stakeholders, which even the GDPR does not do. They put in place, yes, it's all about internal mechanisms, compliance mechanisms, saying, what do you do? What are your processes? but it's so framed towards these are the things you have to do. And if you start reading it and realize like, oh, what they're doing here is they are shifting the Overton window by saying like, oh, it's just an impact assessment. Don't worry about it. It's an impact assessment. But by the way, in that impact assessment, you've got to uncover the actual measurable impacts on people on the basis of race, sex, and gender. And you have to tell us what you've gotten from impacted communities and why you've refused to take it into account when you've been actually designing your process, like your product. And you have to do ongoing performance review. You've got to let the FTC know on an ongoing basis what's actually happening to your product in the wild. And you know what? We're not going to release these because we're America. And we think of compliance as being like internal entity risk management as opposed to actually like an accountability regime. But what we're going to do is the FTC is going to release parts of it, and it's going to publish annual reports that's going to say like, this is what's happening. These are the bad actors. This is the percentage of impact on people on the basis of race and gender. And so that's one example. The other one I'll say is from my home state of Colorado. So there is a proposal to regulate facial recognition. It's gotten through the House. I don't remember if it's gotten through the Senate. It is largely, again, impact assessment based, and attached to it is a moratorium on facial recognition in schools. So there are these places, and there's another one. There's a Washington Act too, that is an impact assessment act that actually like allows for substantial enforcement against public entities, but allows for substantial enforcement against public entities for substantive problems, not just on the basis of failure to disclose. So what I'm seeing is like in the nitty-gritty things on the ground, very slowly, there are these places where we can highlight these differences. And my pragmatist hat is saying like, oh, please, let's take those and attach those to other laws, as opposed to decrying the laws and saying like, this is just hopeless and we can't do this.
So thank you all for really a great conversation. I think there's a lot here. I think there's room for optimism and pessimism. I think one optimistic thing in the laws that I see, and it remains to be seen, is that for a long time, regulating design was kind of the third rail. Like, we don't touch it. Oh my gosh, if we regulate design, that is too encroaching and paternalistic on what companies can do. But now the laws are starting to do that. They just call it something different. They call it a dark pattern. Well, of course we can regulate dark patterns. They're evil. They're ominous sounding. But dark patterns is basically regulating design. It's regulating a lot of interface design. And if you called it design, it might not go anywhere. Now, it remains to be seen how aggressively they're regulated, but I think that it opens the door to something potentially good. So I think there's some good, but I definitely think privacy law still has a long way to go. And I think the laws out there, you could be doing a lot more, and we want to push them and to sort of how radically can we go. I wish we had more time to discuss everything, but I want to give people the rest of their afternoons back. So we'll end here, but the conversation will certainly continue on. So thank you all for joining me, and goodbye.